Alright, Title 40 CFR Chapter 1, July 1st, 19 edition. We're looking at Part 224, Rules Governing Issuance of Administrative Hearings, Interim Status, Corrective Orders. 2401, Scope of Rules. 2402, Initial Issuance, Initial Orders, Definition, Final Orders, and Consent. 03, Maintenance of the Document Officials. 04, Final Service of Orders and Decision Documents. 05, Response to Initial Order Request for Hearing. 06, Designation Presiding Officer. 07, Informal Settlement Conference. 08, Selection Appropriate Hearing Procedures. Subpart B, 2409, Qualification Presiding Officers, ex parte decision of the proceeding. 2410, Scheduling a hearing, pre-hearing submission by respondent. 2411, hearing oral presentation written submission by parties. 2412, summary hearing presiding officers recommendation. Subpart C, hearings order requiring corrective measurements. 2413, qualification procedures, ex parte decision of proceeding. 2414, scheduling a hearing, pre-hearing submissions by parties. 2415, hearing oral presentation, reading, and submission by parties. 2416, transcript or record of hearing. 2417, presiding officer recommendation. Subpart D, post-hearing procedures, final decision. 2418, 2419, final order. 2420, final agency action. Alright, subpart A, general scope of these rules. The rules establish procedure with the governing issue, the administrative order with the corrective action pursuant with section 3008H and 3003H of the Solid Waste Disposal Act amendment with the Resource Conservation and Recovery Act and conduct with the administrative hearings such as the orders except the specified in paragraph B and C of this section here is a procedure of the administrative appearing in Title 40 CFR Part 22 governing the administrative hearings and order to issue pursuant to section 3008H of the Act at which one is contained within the administrative order with include the claims under section 3008 of the Act includes the suspension, revocation, and authorization appropriate under 3005E of the Act, seeks penalties under section 3008H2 of this Act with the non-complying with the section 3008H of the order, the hearing procedure of the parent with the Title 40 CFR Part 22 to govern the administrative of the hearings, any order issued pursuant to section 9003H of the Act with the name of the administrative order with the claims under section 9006 of the Act. Questioning arising in any state of the proceeding which are not addressed of these rules, the result of the discretion regional administrator of the presiding officer is appropriate. 2402. Issuance initial order definition of the final orders and orders of consent. Administrative action under section 3008H and 9003H of the Act shall be commenced, and by issuance of administrative order where the order is issued, the unilaterally with the order shall be referred to the initial administrative. The order may be referenced proceeding under section 3008H and 9003H of this Act. The order has become effective either the issuance of the final order following with the final decision made administrator after 30 days of the issuing no hearing is requested. The order shall be referred to the final administrative order. Orders agreed by or to by parties. Order shall be denominated final administrative order with consent. Initial administrative order shall be executed by the authorized official of the EPA, petitioner other than the regional administrator, the assistant of the administrator of the Office of Land and Emergency Management for orders issued with the Environmental Public Protection Agency headquarters rather than the regional office. All references to these procedures on the regional administrator shall understand by the assistant of the administrator of the Land and Emergency Management of the delegate with the title initial administrative order shall contain a reference of legal authority pursuant to the order is issued with a consistent statement of the factual basis upon which the order is issued. Notification respondent right the request of the hearing respect to any issue material fact of the appropriateness of the proposed corrective action. 2403, maintenance of the docket official record. A clerk shall designate with the regional administrator of the receipt of all the initial order, final order, decision, respond with a memorandum of the document regarding the order that has been maintained in the official record and docket. On before and the day of the initial issue order is served, the respondent with the EPA issuing the order shall deliver to the clerk the copy of the administrative record supporting the finding of the in fact, determination of the law of the relief of the sub of the initial administrator of the record shall include all relevant documents or oral information which is produced in writing to writing the agency considered and is also in issuing the order. Exclusive privilege internal communication administrative record declared delivered to the clerk must be having an index available for the review of the appropriate agency of the regional headquarters office during the normal business hours and order after the order is issued. Alright, 2404, filing service order of the decision document. The filing order decision for the documents for the original one copy of the initial administrative of the order with the recommended decision with the presiding officer of the final decision, final administrative order, one copy of the administrative record, index thereto may be on file with the clerk. Designated with the 3000H and 9003H order of the nation with all the memorandum of the documents submitted within the proceedings shall be filed with the clerk. Service order of the decision ruling. So, clerk can order in the case of the initial administrative order and other designated of the EPA employee shall arrange the evacuation service effectuation service of the initial administrative order, recommended decision of the presiding officer, the final decision, final administrative order, service a copy of the initial administrative order together, a copy of these procedures of the recommended decision, presiding officer, the final decision, final administrative order shall be made personally by certified mail with the return receipt requested. If the personal service cannot be effectuated with the certified mail with the return refused, with the resigned unsigned regular mail with the respondent with his or her representative, the clerk shall serve the other documents from the presiding officer by regular mail. Service of the documents filed with the party with the service of all of the documents filed by the party shall be made with the party with the other representatives with the other party with the representative made with the regular mail by with the original file with the clerk of the original and any pending letter and any other document other than the exhibit that shall be signed by the party filing by his or her counsel with the other representative. The signature constitute a representation by signer that has read with the pleading of the letter of the other document to the other estimate of the knowledge information belief of the statement that made there are true and that is not interposed to delay. The service in general for the service of the order decision ruling the documents either by the clerk of the party shall indicate that the domestic foreign cooperation partnership with the other incorporated association with subject to the suit under common name be made prescribed in 2404 BC and under officer partner and managing general agent any person authorized in appointment by the federal and other state law to receive service and process. Effective date of service of the initial administrative order and the final administrative order is complete. Upon receipt of the respondent's agent, attorney, the representation of the person employed with the respondent with the receiving such service personally or certified mail upon the mailing of the regular mail. If personal service by certified mail cannot be accomplished in accordance with 2404B with the service of all the other pleadings, documents is complete by upon mailing except as provided in 2410B and 2414E. Or 2405, request for the initial order of the initial administrative order to become the final administrative order within 30 days after the service, unless if the other respondent filed with the clerk within 30 days after the service of the order respond with the initial order request for the hearing with the response. But the initial order request for the hearing must be written with the mail or personally served within the clerk of the regional office for which of the issue of the order. The response with the initial order of specifically each factual legal termination relief of the provision of the initial order respond with the dispute with the shall be briefed in the case with the basis of the problem with the dispute with the termination provision. Respondent may include that its respond with the initial order of the request for the hearing statement with it indicating whether it believes that the Subpart B or Subpart C hearing procedures shall be employed for the requested hearing on the reasons thereof. 2406, designate the presiding officer. Upon receipt of the request for the hearing with the regional administrator shall designate the presiding officer to conduct the hearing and to preside over the proceeding. 2407, an informal settlement of the conformance of the respondent may request the informal settlement of the conference of the name time with the contact with the appropriate EPA with the employee with the specified with the initial administrative order request for the informal conference will not affect response obligation for the timely request for the hearing with whether or not the respond with the request for the hearing with the party that may confirm with informally with conforming any aspect of the order of the respond with the representative shall generally be allowed with the opportunity to informal conference for the discovery of the appropriate agency for the technical, legal, or personal aspect orders, particularly the basis of the determination for the release of the occurred with the appropriateness of the occurred with corrective action. 2408, selection of the appropriate for the hearing of the procedure step 4 with the subpart B with the part with the employed with the being with the requested hearing if the initial order is direct with the respondent undertake only RCRA facility investigation certificate corrective measures study that will include with the monitoring service the testing of the information gathering analysis and studies including studies developed with the recommendation of appropriate corrective measures or to undertake such investigation studies and interim corrective measures for the interim corrective actions are neither costly nor technically complex that are necessary to protect human health environmental prior to the development of the permanent remedy or the undertaken investigational study with respect to the release for the underground storage tank hearing procedure set forth in subpart C with being part of the employee with the respondent seeking the hearing in order to directing that corrective measures such as the corrective measures together and investigation studies be undertaken corrective action such corrective action together with investigation studies undertaken with respect with any with the release underground storage tank procedures contained in subpart A and D with the subpart with the followed regardless of whether the initial other directs of the respondent to the undertaken the investigation pursuant to the procedural subpart B with the subpart requirements the respondent to implement corrective measures pursuant to the procedures subpart C of this part. Subpart B, hearings, orders requiring investigation or studies.